Today, we're going to be talking about citizen lawsuits, specifically around how to prevent, litigate, and also settle Clean Water Act citizen lawsuits. We're really excited to have Nathan here today, and he's going to dive into kind of the background on citizen lawsuits, what they mean, what the process is, and some steps that you can take if you get a 60-day notice or if you're in the middle of negotiations around a Clean Water Act lawsuit, what you can do to potentially reduce the financial impacts and the impacts to your business.
What is the process? How does this start? What do you do? How do you react? Before a citizen can file a citizen suit, Clean Water Act requires them to send a 60-day notice of their intent to file suit to the entity. They also copy the state regulator, in this case, a regional board, a state board, and EPA. What the 60-day notice does is informs about the alleged violations. It's really an opportunity for you fix any issues that can be fixed, and an opportunity to open up settlement discussions early. One thing that I've seen frequently, I will get a call from somebody saying, I just got a lawsuit, I don't understand. They sent this letter a few months ago and we told them that there weren't any issues, everything was okay. They won't respond to those letters. Those letters usually will say to engage an attorney. If you write back on a 60-day notice, you may get a letter back saying thank you, but we still intend to file a suit if you get anything. And then eventually they will file a suit. So it is an opportunity to open up discussions, start the settlement process, and just kind of understand their claims. So take full advantage of that 60-day period, including a chance to fix any allegations. So what do you do? This probably seems self-serving to the first bullet, to hire counsel. There's a couple definite benefits to it. One is automatically the discussions that you have are attorney-client privilege. So we can look into your records. We can have frank, open discussions. We can send emails back and forth between management and staff, people on the ground that are actually running the program. That all becomes protected under attorney-client privilege, attorney work product. Likewise, if you hire a consultant, the consultant can work through the attorney and all of that information becomes privileged. One thing to keep in mind is that you have to keep all your records. There's something called a litigation hold. As soon as you receive that 60-day notice, that's the prelude to litigation. So you can't destroy any of your records. So if there's skeletons in the closet, eventually they'll come out. It's also a good idea to get the consultant on board early. They can help with thinking about settlement strategies, how defensible from a technical standpoint your stormwater program is, so you might be able to lessen the impact of potential litigation. The other thing that an attorney can do, especially someone who practices in this area a lot, is engage the citizen enforcer. As soon as I get a call, somebody has an issue and we sign them up as a client, I call opposing counsel, and I've worked with these people and done numerous settlements. So we kind of talk the same language and understand what's going on, so that they're not gearing up necessarily for a long fight. They're gearing up for what makes sense under this potential situation. But it's a good opportunity to also eliminate potential violations. Is your SWIP up to date? Is your map up to date? If those are allegations in the 60-day notice, fix them. Because again, the 60-day period is the opportunity to fix these issues. It probably won't make the entire lawsuit go away, but it'll make the settlement easier potentially. Is there stuff that can be removed from the site? Is there stuff that you can cover, take inside that they allege is outside? Are your BMPs functioning? Can you do some quick revisions, update your SWIP, get a copy over to them so that they back off on some of their allegations? Can you, on a larger scale, eliminate discharges? Is there anything that you can do to combine discharge locations or do any type of treatment if necessary to address discharges?
Can you just touch on, like, somebody gets a 60-day notice? What are some of the initial steps that they should go through, like day one, first week, etc.?
The first thing I do when I'm brought on, and earlier in the 60-day notice process, the better, is I reach out to opposing counsel and say, hey, I'm representing this organization. We've got your 60-day notice. We're going to take a look at it. Is there anything you want to tell me about this? And then usually you'll exchange some information. The first thing that the client should obviously do is start digging into the allegations and start looking at what your liability is. I mean, is it total BS? Or do you have some issues that you haven't addressed very well? Start thinking about that. Start thinking about what your liability is. Obviously, start fixing stuff. Again, the allegations have to be ongoing violations. So anything that you can fix so that it's not ongoing, and show the other side. When you go to negotiate the settlement and they come out with a number, you say, well, wait, that doesn't make any sense. We've already done A, B, C, and D. Our SWIFT has been updated. We put in additional BMPs. We moved this material inside. As a result of that, this discharge location, we're not going to be discharging there anymore. All those types of things come into play once you dig into the settlement discussion. So I guess it's three things: engage the opposition, get a consultant, or if your staff can do it, start digging into the allegations, seeing where you have weaknesses and where your strengths are, and then fix as much as you can in that 60-day period.